controversy. He refuted and he rebutted the testimony from Jody Wilson-Raybould last week, in which she alleged that Gerald Butts, among others in the Prime Minister's office, and the Prime Minister himself, applied inappropriate pressure on her to intervene in her role as the Attorney General, her former role as the Attorney General, in that SNC-Lavalin criminal case. We're hearing again from Michael Wernick. We've heard from him before. He actually has already testified, and so has Ms. Durand in front of the Justice Committee. Both of, well, especially Mr. Wernick, he put forward a testimony and put forward comments that, again, sort of agree with what Mr. Butts put forward today, in that they feel like the meetings that took place between themselves and Ms. Wilson-Raybould, or other people in the Prime Minister's office and Ms. Wilson-Raybould, were all above board. They were within the normal operation, the way government works normally. Of course, Jody Wilson-Raybould has said otherwise. She has said that, in fact, that testimony, or that, I'm sorry, those meetings were inappropriate. She said she was subjected to consistent level of pressure from, again, people in the Prime Minister's office, like Gerald Butts, to intervene in this criminal case. And what's being alleged in that criminal case is that SNC-Lavalin, which is a big company here in Canada, employs about 9,000 people, headquartered in Quebec, was facing charges of corruption and bribery for some things that they had allegedly done in Libya. They were looking for a way out of the prosecution of those charges, something that's called a deferred prosecution agreement. It's a remediation agreement, newly available kind of in Canada, that would allow them to avoid criminal conviction, but they might have to pay a big fine or show that they've made changes that address the kinds of allegations that they were facing, the kinds of charges they were facing. They had hoped to secure that type of agreement. The Director of Public Prosecutions made the decision not to go ahead with that, to instead proceed with the prosecution. And what was at stake here, what was being discussed, debated, whatever you want to call it, was whether or not Jody Wilson-Raybould, as the Attorney General, should intervene in that decision, should essentially reverse it. If she had done that, if an Attorney General does that, they have to make that decision public. But clearly, from the testimony of Jody Wilson-Raybould, she did not want to intervene in it. She had made that decision. What Gerald Butts said today is that she never communicated that decision in writing, and he considered that to be significant. We're still waiting, I should mention, for Mr. Wernick to testify. He is the clerk of the Privy Council. He has testified before, as I mentioned. Next to him, Nathalie Drouin. As we wait, I want to bring in the power panel, because they're going to be watching this whole thing unfold with me. I've got in Calgary, Marcella Monroe of KTG Public Affairs. Oh, never mind. I'm going to cut the power panel off, but they're going to be standing by. We're going to discuss this after the testimony. Let's take a listen in. That's Anthony Housefather, the chair of the Justice Committee. He'll kick things off, and again, we're going to hear from Michael Wernick.
The Office of the Attorney General and government colleagues.
I would like to welcome today from the Privy Council's office, Mr. Michael Wernick, the Clerk of the Privy Council and Secretary to the Cabinet. Welcome, Mr. Wernick.
Point of order.
Point of order, Mr. Cooper, yes?
Thank you, Mr. Chair. I would request once again that the witnesses be sworn in. Clearly, the testimony of Mr. Wernick, the last time he appeared before our committee, is in many areas inconsistent with the testimony that Ms. Wilson-Raybould gave. Given the gravity of the allegations and the very detailed testimony of Ms. Wilson-Raybould, I think that in the circumstances, it is appropriate that both of the witnesses be sworn in. Thank you, Mr. Chair.
Mr. Cooper, I'll repeat what I said this morning, that no witness has been sworn in this committee for the last 25 years at least. That witnesses are required, and I'm reminding the witnesses, of course, they're required to tell the truth before committee. You can be charged with contempt of Parliament if you mislead the committee. But since Confederation, nobody has ever waived parliamentary immunity to charge somebody with contempt for misleading a committee. So that's why, out of practice, the committee has not done that, but we will have a vote per Mr. Cooper's, a recorded vote by Mr. Cooper, certainly. And this would apply to both witnesses.
Both.
Okay. Okay. Mr. Clerk?
Merci.
By the way, so those voting aye are voting to swear in the witnesses. Those voting nay are saying it's not necessary. Mr. Clerk?
Monsieur Boissonneau.
No.
Mr. Assassi.
Nope.
Mr. Fraser. Ms. Khalid.
No.
Mr. McKinnon. No. Mr. Barrett.
Yes.
Mr. Cooper? Yes. Ms. Wright? Yes. And Mr. Rankin?
Yes.
Yeas pour, 4, 4, and nays contre, 5, 5.
Thank you very much. So that motion being defeated, I'm going to return to welcoming again Mr. Michael Wernick, who's the Clerk of the Privy Council and Secretary of the Cabinet. Thank you very much for coming back before us, Mr. Wernick. Et aussi à Madame Nathalie Jou-
Also, we'd like to welcome Ms. Nathalie Drouin, who is the Deputy Minister of Justice and Deputy Attorney General of Canada. So thank you very much for being here today, Ms. Drouin.
And we have allocated 15 minutes to each witness for opening statements, and we will start with Mr. Wernick. Mr. Wernick, the floor is yours. Oh, sorry. Before we start, excuse me, no time. We have Mr. Wernick's and Madame Drouin's opening statements that we have distributed to committee members. We also have the undertakings from Mr. Wernick from his last appearance before us to provide certain notes and correspondence that he had agreed to provide. We have those here. Some of them, much of it is bilingual, some of it is in English only. So I'm requesting the committee's permission to distribute it, despite the fact that some parts of it are not translated. Does the committee agree to have it distributed regardless? Everyone okay? Oui, Monsieur Plamondon?
Mr. Plamondon, I know that I can't object legally, but I'm very disappointed that we're not respecting one of the two official languages of our country fully. But I'm not opposed, since I don't have the power to do so, since I'm not a member of this committee.
Monsieur Berthold?
Mr. Beltod? Chair? This is the second time that this committee has not respected their responsibility to have documents in both official languages. We won't oppose these documents, but I would like you to inform all witnesses and members of this committee how important it is to transmit all documents in both official languages so that we can have access to the information in the language that we have the right to have access to it in. Generally, it's not the duty of the witnesses to do so. It's the duty of the clerk and the committee to translate the documents. And generally, we don't give everyone documents that are translated because it creates a time lag, and therefore we asked if we were ready to distribute them beforehand. Chair, given the subject, I won't object, but what I would like you to do is to reiterate to the witnesses before they appear is to give us documents in both official languages, because this is the second time the committee has done this, and it would be important for this not to become a habit. Yes, we will accept unanimously to have these documents distributed. It's only so that everyone can have documents in time today, but I agree entirely that we want all documents to be in both official languages. That is the practice of our committee. I hope that the documents will be translated in both official languages eventually. Yes, and given to all members. Yes, just for everyone to know, when we do receive documents, it's our responsibility as a committee to translate them, and we do distribute them afterwards. Sometimes, such as today, we want to have members to have access to these documents, but yes, of course, the committee will translate them, and then they will be distributed in both official languages of Canada. So I understand, Mr. Plamondon, your concern, but I do realize that it's important today to be able to listen to the witnesses, and we have all the documents at our disposal.
We will now move to Mr. Wernick. We will distribute this, Mr. Clerk, and we will move to Mr. Wernick's testimony. Mr. Wernick, the floor is now yours. Thank you, sir.
Monsieur le Président.
Chair.
There are, two new facts since I last appeared at the committee some 2 weeks ago. One is the waiver that was offered to witnesses, so that will allow different lines of questioning by the committee members. And the other, apart from my cold, is the kind of traffic that I have received on social media, and I would like to present these to the committee. If somebody could please transmit them to the clerk. And I would ask the committee...
relevance, point of order, what is the relevance of social media to what we're doing in terms of reference
If I could explain...
whether a line was crossed,
If
Mr.
I could
Chair?
explain...
Yep, of course, Mr. Wernick. Go ahead. Stop time. Go.
I believe that you will want to discuss this as the intimidation of a witness before your committee and a breach of the committee's privileges. You can take that up in camera if you wish. I will be distributing these to the media.
Okay, thank you very much. Since I haven't seen them, I'm not going to say anything right now. I just asked to move back to your opening statement, and the committee will consider it at a future date or when we're ready. Thank you very much, Mr. Wernick. Please go back on time.
Thank you. So, Monsieur le Président,
Chair.
it has been suggested that my testimony to the Justice Committee on February 21st was partisan, presumably in content or motivation. I would like to respond. I would also like to provide the committee with my recollection of conversations I had with the former Attorney General. I want to first clarify my role within the Government of Canada as Clerk of the Privy Council. I am the Deputy Minister to the Prime Minister and Secretary to the Cabinet. In the first role, I'm charged with delivering advice to the Prime Minister and assisting him in delivering his agenda. I've had a close working relationship with the Prime Minister for more than 3 years, sitting in on countless meetings and discussions covering the entire range of government activity. I work at the intersection of the public service and the elected officials, and I am present for many discussions that touch on matters that some would see as political. It is my role to be aware of this context, but I do not ever give advice that is partisan in content or motivation.
As clerk, it is part of my job to give the Prime Minister impartial advice and feedback on how his ministers are exercising their roles, their relationship with colleagues, and with the public service. The Prime Minister and his staff seek my advice before cabinet shuffles, and I have been the main advisor on appointments and deployments of deputy ministers.
As Secretary to Cabinet, my job is to ensure the smooth flow of decision-making through the cabinet system. The most scarce resource in Ottawa is time at Cabinet, and I work hard to ensure discussions are well prepared, due diligence has been exercised, and options crystallized so that ministers in the Cabinet room can focus on the key aspects of decisions before them. Part of my job is to keep the government's agenda moving. En tant que 23e greffier,
as the 23rd clerk, I have tried to be open with Canadians about my role and my perspectives. I communicate with them through a website and presence on Facebook, Twitter, and LinkedIn. All of my speeches are posted. I have given media interviews, and I have appeared before parliamentary committees. As head of the public service, I submit a report to Parliament and Canadians every year on the state of their public service. I have always tried to be direct in my language.
I am profoundly disappointed to be accused of partisanship by people that have never met me. My career is on the public record. I have held the highest security clearances that this country can offer for many years. I was named to deputy minister level positions by Prime Ministers Chrétien, Martin, Harper, and Trudeau. I participated in the transition exercise, the swearing in, and the first cabinet meetings of Prime Ministers Martin, Harper, and Trudeau. I have attended more than 200 meetings of cabinet and its committees since 1987. I have attended First Ministers' meetings with 4 prime ministers in the chair. I set this out because it's been suggested that I'm part of someone's political agenda. I serve the government of the day. So turning to the discussion at the Standing Committee on February 21st, my comments about the ethical conduct of the government, and previous governments for that matter, were not motivated by a desire to burnish their image. I have spent thousands of hours with politicians and political staff from all stripes. And I am in a unique position to attest to Canadians through you, from personal experience, that they are well served by the women and men who work in the offices of the people that they elect. Since I was last here, there have been a few developments. One is that several people have suggested I am more political than a public servant should be. I hope I've clarified that I understand my role in government. And the other development is the waiver, and that the former Attorney General has testified. I will not respond to all of her evidence, but I do want to make a few points before we begin questions. My understanding is that one purpose of deferred prosecution agreements is that corporate criminality does not devastate workers, pensioners, suppliers, and others who did nothing wrong. This is in the criminal code, and it is part of public interest considerations. In speaking to the Attorney General in December, I was giving her contextual information about the SNC-Lavalin matter directly relevant to a decision she had to make. In dealing with the public interest, the Attorney General's decision is never final. The public interest can evolve and change, and the impact of a decision to prosecute or not prosecute was evolving in this case. When I mentioned to the Attorney General on September 17th that there was an election in Quebec, I did not do so out of any partisan consideration. That is an unfair inference. It is a long-standing convention for the federal government to try to stay out of the fray of provincial election campaigns and let the people of each province decide for themselves who they want to govern. In mid-September, based on the company's public disclosure obligations, I was concerned that a purely federal issue could surface in the last 2 weeks of that rather heated campaign. And it is my job to remind elected officials about those conventions. Lorsque je lui ai mentionné le 17 septembre que le Québec était en
On September 17th, when I mentioned that Quebec was in an election campaign, I didn't do so for partisan reasons. This is an unfair inference. It is a long-standing convention for the federal government to stay out of the fray of provincial election campaigns. In mid-September, based on the company's public disclosure obligations, I was concerned that a purely federal issue could surface in the last 2 weeks of that campaign. It is my duty to remind elected officials about those conventions.
I assured the Attorney General in my presence in September and in writing in December that the decision about prosecution was always hers to take. The Premier Ministre a assuré le Procureur Général d'abord.
The Prime Minister assured the Attorney General in my presence in September and in writing in December that the decision about prosecution was always hers to take.
On January the 10th, the cabinet shuffle was finalized, and the next day, in the context of calling 5 deputy ministers who were affected and would have to be ready by Monday, I called Madame Drouin and asked her to make sure that the new Minister of Justice and Attorney General would be brought up to speed on a number of prominent files that he would likely face questions about in the near future, perhaps as soon as the cabinet retreat in Sherbrooke, which would begin on Wednesday afternoon, 2 days after the swearing-in. I mentioned carbon pricing litigation, the Norman trial, TMX, and SNC-Lavalin. I don't know if the Deputy Attorney General will agree with my recollection, but I never singled out SNC as the only issue, and it would be a misreading of my conversation with her to suggest it was. Je maintiens totalement.
I stand by my testimony of February 21st. And in terms of the testimony of the former minister on February 27th,
after the former minister's testimony, the following facts are not contested. She was always the decision maker. She was assured multiple times that she was the final decision maker. The former minister agreed that entering into a deferred prosecution agreement would have been entirely lawful. Je souligne que la suite des témoignages de l'ancien ministre,
I would like to note that after the former minister's testimony, the following facts are not contested. She was always the decision maker. She was assured multiple times that she was the final decision maker. The former minister agreed that entering into a deferred prosecution agreement would have been entirely lawful.
the former minister maintains that her decision, a decision to take no action, was final in September. But she had the ability, as new public interest considerations emerged, to reassess the context and re-examine her reasoning, and that is the most she was ever asked to do. So I repeat my contention: the minister experienced lawful advocacy to consider doing something lawful in the public interest. I made no threats, veiled or otherwise, that the minister's decision would lead to consequences for her, and my position could be captured at all times by the well-known phrase non-ingérence non-indifférence. It is my contention the minister was doing her job and I was doing mine. Je soutiens que la ministre remplissait son rôle.
I would like to repeat my contention that the minister
Like the former
fulfilled his
minister, I have sought
Prime
legal
Minister
advice
fulfilled
about
his
what
role.
I can and cannot say today. And I've been advised not to opine on the minister's reasoning or state of mind because some of the issues are or will be before the courts. So, my recommendation to the committee would be to develop an all-party report proposing improvements to the law around deferred prosecution agreements. Your recommendations could be adopted by the House in a single sitting day and become law before the end of this Parliament. This committee may also want to further explore the potential separation of the Attorney General function with a view to informing Canadians, and it would permit each party to take a clear position on this matter during the imminent election campaign. This is a profound change that could have consequences intended and unintended for decades to come and should not be rushed. Finally, this is the Justice Committee, and the committee may wish to hold hearings on the Attorney General of Canada's Directive on Civil Litigation involving Indigenous peoples, which she issued on January the 11th, 2019, effectively her last day on the job. This directive to all Government of Canada litigators could mark a profound change in Canada's legal landscape. However, it could be repealed or gutted at the stroke of a pen and all that work turned to ashes. So I think now that all political parties need to be clear with Canadians on the future of that directive. That is my opening statement. I'd be happy to take questions from the committee.
Thank you very
And,
much.
thank you for your patience.
Thank you very much, Mr. Wernick. We're going to turn now to Madame Drouin. Madame Drouin.
Hello, I'd like to thank the members of the committee for allowing me to make this opening statement. My opening remarks will address my role and responsibilities as Deputy Minister of Justice and Deputy Attorney General of Canada, my professional relationship with the Honourable Jody Wilson-Raybould, and my chronology of events. As Deputy Minister of Justice and Deputy AG of Canada, I support the Minister of Justice and Attorney General and the government in the development of their policy objectives. In the exercise of my duties, my vision has always been the provision of high-value legal services. Given the traditional role of jurists, I would ask you to I always have a strategic alliance with customers, working as partners, focused on finding solutions and delivering results.
I have the privilege of working with highly competent and impressive individuals. The former minister and Attorney General and I had a very positive working relationship. I commend her for what she brought and brings to Canada in her role in public office. I can tell you that I learned very much and a lot working with her, especially in terms of Indigenous issues and lawmaking. In fact, we continue the work she began at Justice Canada by taking a new approach to Indigenous litigation. I hold myself and my staff to the highest standards of providing nonpartisan advice. My role is supporting the ministers and Attorney General demands that I uphold the values and ethics expected of me, both as a public servant and as a lawyer. I would like to begin by describing my dual role as a Deputy Minister of Justice and Deputy Attorney General. I have been in this position since June 2017. In both these roles, I support the Minister of Justice in fulfilling his or her responsibility. My functions include giving legal advice and coordinating the legal advice given by the Department of Justice, supporting the development of legislation and policy that fall within the justice portfolio, as well as acting as the formal representative of the Crown in all civil litigation involving the Government of Canada. In addition to my support, the Attorney General of Canada is also supported by the Director of Public Prosecutions, who is also a Deputy Attorney General of Canada. The DPP and I do not report to each other. It is not my role to discuss specific prosecutions with her, and I have not discussed the substance of the SNC-Lavalin prosecution with her. However, I do provide advice to the Attorney General of Canada in her or his decision-making as to whether or not to issue directives to the Director of Public Prosecution or to assume the conduct of a federal criminal prosecution. In such situation, I approach giving legal advice in the same way I would when giving advice on any other statute, but with careful attention to the distinction between my job and the job of the DPP. Monsieur le Président, comme le permet
Chair,
le décret rendu par la gouverneure générale en conseil le 25 février
by the scope of the order in council that was enacted by the Governor General in council on February 25th, 2019, I would now like to provide the committee with a detailed account of my interactions on this file. In order to provide you with this account to the best of my ability, I have reviewed my emails, files, and agenda. I have not consulted Ms. Wilson-Raybould, the Minister Lametti, or their staff, or anyone outside of the department on facts that are my own. My account will include details of the discussions that I had with the former Attorney General respecting the exercise of her authority pursuant to the Director of Public Prosecutions Act. September 4th. On September 4th, the department became aware of the director's position to continue with the prosecution of SNC-Lavalin. I would like to clarify that on that, I still don't know how or when the director's position was shared with SNC-Lavalin. On September 5th, as I mentioned, I have reviewed my calendar to my best ability. My calendar indicates that on September 5th, I had a phone conversation with Paul Rochon, Deputy Minister of Finance. However, I cannot recall whether we talked about this file, another file, or both. Moreover, when I can recall that a first discussion that I had with Ms. Wilson-Raybould on this file was on September 5th, late in the afternoon. The purpose of the call was to discuss another file, but from what I recall, SNC was also discussed on the margins. The former Attorney General was in Fiji, and there was a 17-hour time difference. Two of her staff members, Jessica Prince, Chief of Staff, and Emma Carver, Policy Advisor, joined the call. We agreed that the department would provide advice on the role of the Attorney General for her consideration. I told them that the department had begun working on the advice the evening before.
September 6th and 7th. For the 2 next days, my official and I developed a written advice. I also provided verbal advice to the AG staff, Emma Carver and François Giroux, on the Attorney General's power under the Director of Public Prosecution Act. I advised that it would be very important for the Attorney General to be comfortable with the Director position to not pursue a remediation agreement. I emphasized that the Attorney General was entitled to receive as much information as she considered necessary from the Director. It was during the course of these conversations with Emma Carver and François Giroux that they read to me the extract of the Section 13 letter from the DPP. For clarity, a Section 13 letter from a DPP to the Attorney General is to inform the Attorney General in a timely manner of any prosecution or intervention that the DPP intends to make that raises important questions of general interest. As I have explained to the committee, in fulfilling my role as Deputy AG, I am very careful to separate my role and responsibility from that of my counterpart, the Director of Public Prosecutions. As I have mentioned, I have no role in specific criminal prosecution and am not privy to any of the evidence. This is why I refuse to review and receive the Section 13 letter. It was during the same conversation that Emma Carver informed me that she was drafting a document that she intended to provide to her counterparts at the Prime Minister office. I was also told that the Attorney General was not keen on the idea of exercising her authorities under the DPP Act. In her testimony, the former minister mentioned that I had conveyed information from the Department of Finance. to clarify, on September 7, I spoke with the Deputy Minister of Finance, Paul Rochon, and he had questions regarding the decision-making process and the roles and relationship of the AG and the Director of Public Prosecutions. Also, on September 7, I spoke to the former Attorney General's Chief of Staff and provided her a verbal outline of what we were drafting for the AG's consideration. On September 8, I provided a draft opinion to the former AG's office. The opinion is entitled, "The Power of the Attorney General to Issue Directives and to Assume Conduct of Proceedings." Sorry. The opinion begins with a discussion of the Attorney General's independence and her ultimate responsibility for criminal prosecutions. It describes the role of the DPP in much the same way I have explained to this committee. It also describes the power to assume conduct of a prosecution and the power to issue directive. The opinion also provides advice to the AG on the role of the DPP and that the AG is entitled to receive information from the DPP in order to understand the decision. Various options are set out in the situation where the AG either disagrees with the director's position or wishes to further assess the decision. These options include the issuance of directives that direct reconsideration or appoint a specific prosecutor to reassess. Another option covered is for the AG to decide to assume conduct of a prosecution, consider whether statutory conditions for remediation agreement are met, and if so, appoint an agent to negotiate such an agreement. The legal opinion also canvasses the possibility of seeking outside advice with respect to the AG's power under the Act and the Criminal Code in order to assess whether the conditions for a remediation agreement are met. The legal opinion advises that the relevant constitutional and statutory framework prioritize independence and transparency, and that any decision by the AG is hers to make, independent of the political consideration or processes. There is also a short discussion of the deference by courts to prosecutorial discretion, which can be reviewed only for abuse of process. Je voudrais apporter un peu de contexte.
I would like to provide some context on this part of my remarks. While I've been at Justice Canada for almost 3 years, as you know, I also worked in Quebec in similar roles. During that time, I gained expertise in this area as I faced similar situations where decisions of a DPCP were publicly challenged and where an Attorney General was called upon to act. I appropriately brought this professional experience and expertise to bear on the advice my department provided to the Attorney General in this matter. September 10th, the department responded to 2 follow-up questions that we had received from the Attorney General's office as a result of the draft advice. On September 11th, the Attorney General's acting Chief of Staff, François Giroux, informed me by email that the Attorney General was not intending to intervene in the case and that she would be pleased to discuss it. On September 12th, the next day, the Department of Finance indicated to me that SNC-Lavalin was still in discussions with the DPP. I therefore understood that the DPP's position on whether to invite SNC to negotiate a remediation agreement was not final.
On September 12 or 19, and I would like to be more precise, but I don't have any evidence on that, I have a discussion occurred with the clerk on the margin of a weekly meeting that we call the DM breakfast. I recall that I had a discussion with the clerk where we discussed options that the AG had available to her, her role, the DPP's roles, as well as my role. On September 16, I had a call with PCO where we would have discussed also the advice of the AG. To the best of my recollection, my first face-to-face meeting with the former Attorney General on this file was September 17, and I believe we may have only briefly discussed it on the margin of another meeting. I also saw the minister on September 18 and 19. On September 18, the only purpose of the meeting was for the minister to debrief on her meeting the day before with the Prime Minister. I do not recall her specific words, but I remember her telling me that the clerk was present. She also expressed to me that she was not comfortable with the content of this conversation. September 19. During my bilat on the afternoon of September 19 with the former AG, she told me that she just had a discussion with the clerk. During the same meeting, I clearly recall that the former AG said to me that this would be the last time we discussed the SNC-Lavalin matter, and she also instructed me not to have any discussion with the DPP. To the best of my knowledge, and to be clear, after September 19, I did not have any further involvement on this file with the minister and her staff, with 2 exceptions. Je tiens à préciser qu'au meilleur de mes souvenirs,
I'd like to specify that, to the best of my memory, my last contact with members on this file was September 19th, with 2 exceptions. The first of the exceptions occurred on October 19th, when the application for judicial review of the DPP's decision was filed with the federal court. As would be regular process where there's an application for judicial review, officials in my department discussed with the DPP who should appear on behalf of the Crown. The second exception occurred near the end of the month of October. I do not have the exact date. The Privy Council office asked my department for an opinion on the potential impacts on SNC-Lavalin if the prosecution were to result in a criminal conviction. My department developed the draft legal advice. It was not provided to PCO at the